Hey guys, we have another unusual one. Surprise, surprise. This lady is getting kicked out of where she lives because she has a problem with assaulting people, it seems. And of course, it's multiple people and it's all of their fault and not hers. So, yeah, let's see how that goes.
Middleton, can I say something really quick before we start?
Yes.
I talked to I don't know if it's your secretary or somebody, but I did let them know that Monday, I'll be there at 6 a.m. to handle whatever I have to handle, turn myself in, because she just basically told me, my Uncle Tyrone told me I had 4 warrants and I didn't know nothing about it.
Yes.
So I'm turning myself in. I'm not running. I'm not fleeing. I'm not doing any of that. I just got to get a babysitter for my children, and the only person I have is my mom, so she's going to watch them.
I mean, I've heard of people getting a babysitter like to go to the pub or to go shopping or have a nice romantic evening out or something like that, but needing to get a babysitter to go to jail, that is a new one on me. Like, to be so blasé about this whole thing, it's just weird. Anyway, keep watching.
All right. Well, let's talk about this. The attorney isn't here yet, but this is Centerville Limited Housing versus Sinquest Furlough.
Mm-hmm.
This is Thomas Court here in Centerville.
Yes.
Ms. Furlow has 6 active warrants for her arrest, and you know it. And I'm not very happy about it. I've talked to you about this before, and I know you've got a lot of kids and you need to make arrangements, but there's 5 open warrants for your arrest for multiple things.
Sorry.
And you and I have discussed this previously.
Yeah, we did. And I don't lie to you or anything. I'm gonna tell the honest to God truth. When I called and she told me that some of them only one of them was a no bond, I asked her what was that. She said that all the rest of them was like $100 fines or whatever. But she did say the one with no bond was an aggravated assault, and I was kind of took back by that, because the stuff that I've been going through it over here, it's been really, really bad, but it's only been with the male neighbors. So I have everything to show you. I'm not going to lie to you about anything. If I would have knew that somebody pressed charges or anything, I would have came right then and there. I got too many kids to be running from the police. That's not my interest. So all these warrants and stuff like that. Last time we seen each other was October 31st the next day after Halloween, when my neighbor was harassing me and I went to jail. So
yeah. All right. Well, the first one is from April. Which case are you here on, sir?
He has a hearing at 10 o'clock.
Okay. All right. Is no insurance, leaving the scene of an accident, open intoxicants, and driving with a suspended license from April of 24. That warrant's been out for a year. Oops.
Just a
minute. I'm just telling you what they are.
Okay.
The next one is a retail fraud that is from December 2nd of 24. The next one is no insurance from May of 24. 9. Driving suspended from May of 24. Darn it. And domestic violence and assault and battery from February of 24. They should have arrested you when they talked to you on that assault case, but
Middleton, not to cut you off, I'm so sorry, but I got before that case, I'm being accused of that case. The only reason I didn't prosecute or anything back, because the officer called me, and the person who I was helping out wanted to get her phone out of my house, and my mom even came. I have witnesses.
Don't tell me any more about it, Miss Furlow.
Okay.
Until we get a lawyer to help you with this.
And I do have I have a lawyer right now, well, legal aid for this stuff that I'm going through, but that me putting my hands on nobody, it never was. So I want to fight that to the full potential. And the Centerville police know that.
All right, well, let's talk about this landlord-tenant case.
Okay.
The manager is here, and Corey Grand Maison is here from Swistak Levine Law Firm that represents this complex. Good morning.
Good morning, Your Honor.
Before you logged in, I was discussing the fact with the defendant, she has several open criminal warrants. She's aware of that, and she intends to come in Monday and deal with those matters. This time, we're dealing with the landlord-tenant case. This is filed as a termination of tenancy action. We'll discuss that. Notice to quit was served on the defendant in February to move by March 6th. As a defendant in a termination of tenancy action, Ms. Furlow, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If you wish to have a jury trial, you have to advise the court here today, or you have to pay the $50 jury demand fee and file a written jury demand within 5 days. You have a right to have the case heard here in St. Joseph County, where the property is located. If you can reach an agreement with the landlord, we could file potentially a conditional order of dismissal. And if the matter could be resolved at mediation and both parties are interested, the court can refer that matter to mediation. So let me make a note here. That's all who's here.
I already have a attorney right now with legal aid.
All right, we'll discuss that. And Joshua, you're the manager at this complex?
Yes, sir, I am.
Just going to take a quick break here in the middle of the video to say thank you so much for watching. I really hope you're enjoying it. If you do, make sure and hit that like button, comment and subscribe and all that good stuff. If you want to support the channel in other ways, you can do so down below by leaving a super thanks, hitting that PayPal link with something in the old tip jar, or grab yourself some awesome Irish Demon merch. There's going to be big changes with a few of the designs and stuff coming up, so that merch won't be available for much longer.
I met you that day that little dog bit me in the foot.
Yes, sir, you did. They're no longer in the park.
I like to know my surroundings, Mr. Cramazon, and I walked over in the park one sunny September afternoon during lunch just to see how things were going, and they've got things situated pretty well. And one of the tenants' little dogs opened the door, and the dogs ran out and bit me in the foot, and she was right there when it happened, but I survived it. All right, also we've got Kyle Evans.
He's my boss.
All right, and you told me that day that the lady was going to be moving out.
Yes, sir.
And apparently that happened. All right, well, this is a termination of tenancy, and I don't know whether this is a subsidized lease. The notice to quit was February 25th. The defendant did not move. It looks to me like the lease is up. Ms. Furlow, you have been in contact with legal aid?
Yeah, I talked to Libby. She said she wasn't going to be able to come to the hearing today, but she'll get right back in contact with me. I did my intake and everything, and I do want to take it to trial because I have all the accuracy that I need. I want to take it to trial.
All right, well, let's talk about this. They want you to move.
Yeah.
Your lease is up. They gave you a month's notice to move, and you didn't move, so they filed this action.
I signed my lease in October, so my lease is up already.
All right, well, let me look. Maybe it isn't up yet.
It's not.
All
I
right,
haven't
well, then
even
there
been
has
here
to
a
be
whole
some,
year.
I can't read it. The print's so small.
Yeah, it's very small.
Mr. Grand Maison, what's the date of the lease?
Allow me to look, Your Honor.
They printed it with four pages on a page. And
Yes, and
I need a magnifying glass to read it.
Yes,
Yeah,
and
literally.
I tell my staff that the cost savings on that is not worth the hassle. Let me look at the signature pages here. The lease was signed on September the 26th of 24.
So it was a year lease, and then after that, it became month to month.
Month to month.
So we're not till September of 25 yet.
No.
Correct. Yeah, the termination is based upon the police report and the violence. It's for a violation of the community rules and the lease provisions regarding behavior. It's not an issue of timing, Your Honor.
All right. Well, I can't tell that from looking at the pleadings.
The complaint itself, Your Honor, it is attached. The notice.
There it is. Yeah. I need a microscope to read that too.
And then the post. Whoa.
All right, hold up, Ms. Furlow.
Okay.
Upon information and belief, you and your guest physically assaulted and threw a pregnant woman down the stairs from your home. Additionally, you committed vehicular assault against another resident of the community. Said act was reported to the police, resulting in your fleeing the scene.
Oh my God.
So this may go back to so it's a just cause termination.
That's correct.
And I didn't put my hands on anyone, and the police was out here. They the one that called my phone to tell me she was sitting on my porch, and she's a good friend of mine. And that man, we got this neighbor. It's a lot going on. So
okay. Meg, are you aware of the circumstance here?
Judge, I am aware that Ms. Furlow has applied for our services, and she spoke with our intake attorney, Attorney Libby McCann, which is who she mentioned. Attorney McCann and Attorney Don Roberts review all of our intake cases and to determine whether they should be assigned out to staff attorneys for further review and follow-up. That is where Ms. Furlow's case is at. That Attorney Roberts and Attorney McCann are reviewing her case and determining level of service.
All right, I'm going to continue this.
Can I take it to trial?
Yes, certainly.
Middleton, I have everything you need, and I only reason I'm taking it to trial because I got a lot. I can't do it all here today, but I will come into the courthouse after I take care of
the trial isn't today, but we'll set it for further hearing next Friday.
Okay.
May 2nd.
Okay.
2025 at 2:15.
Can I come in? Because Monday I'm going to take care of my stuff, so I can come in.
Yes.
Okay.
If you're yeah, we'll get these warrants taken care of.
Yes, sir. That's all I need to do.
Well, you might be in jail.
Man,
I'll make sure
even if I am, I still want to take it to trial. I'm about to
I'll bring you here if you're in jail.
Okay.
All right.
Now, Your Honor, are the warrants related to this incident?
They may well be. One of the warrants is an assault. Let me look at it.
That's the one where they said I put my hands on. I got all the proof. It don't matter.
All right.
My mom was there also, so she got the tape recording.
Yeah, because the incident report on this is from February the 6th. And if the arrest warrant was from that time, there was a recommendation for simple assault based on the incident.
I was in front of the police, so I don't see how that was a simple assault when they called me. And I have
Well,
a video.
just a minute, Let me pull
Okay.
up here. SYNQUES. Ms. Furlow, how many kids are still with you?
I got all my kids. I had never lost custody.
No, I just thought maybe some of them got old and moved out.
Well, Javea is currently, she just turned 15, and today my twins turned 11. Javea has been at my mom's. My mom do help me with my teenage daughter, but the rest of them, no.
Okay. All right, it is alleged that on February 6th in the village of Centerville, that you assaulted Skylar Ballard, a resident or former resident of your household.
No.
Count 1 and count 2, domestic violence. Count 3, assault and battery upon Craig Kloppenstein.
Oh my God.
That's a 93-day misdemeanor. So that was charged by the prosecutor on February 21st.
Okay.
And there has been a warrant for your arrest since February 26th. But apparently Centerville hasn't made much of an effort to serve the warrant.
Yeah, because they know that. Oh my God. You talking about the man that harasses me every day and call me and my kids niggers and monkeys, who came in my driveway when me and my friend Skylar was getting her phone and put the camera.
Well, don't tell me no more about it till we
okay, because I got video
for the park. This is file number 25359 SM.
Okay. I'm not backing down. That's why I record everything.
All right, well, okay, that's fine with me, but send to. I will email you this right now if you give me your email address.
Me,
No, not you, Ms. Furlow. You'll get it on Monday.
Okay.
Yeah. My email address, Your Honor, is my first letter of my first name, C, and then last name, Grand Maison, GRANDMAISON, at Swisstack Levine, all one word, .com. Thank you, Your Honor. I'm in receipt.
There's the affidavit, and here is the complaint. All right, so Ms. Furlow, I don't want to take away any of your rights. Legal aid is reviewing the matter. It's not likely we're going to have the trial on May 2nd.
Okay.
If legal aid does get involved, we will probably use that day to schedule the actual trial.
Okay.
I'm in receipt of both the complaint and the warrant, Your Honor. I appreciate it.
All right, thank you. That just took a second. Meg, are you guys interested in that also?
I was just thinking it would probably be appropriate to share it with us since the court knows that she's contacted us, but we aren't attorneys of record, so
Well, you can share it with your screening staff.
I appreciate that, Judge. Thank you.
It is a public record, so it's nothing secret.
Yeah. That's why I didn't say anything.
All right. Let's revisit this next Friday at 2:15. Ms. Furlow, if you're bond, you can come right in here to the courthouse or you can Zoom in.
Okay.
But if you're in custody, I'll make sure that you're brought in by Zoom.
Okay.
All right. Thank you all. We'll address
Thank you,
this further
Middleton.
next Friday afternoon.
I can't be the only one here that thinks it's a little bit disrespectful to just refer to the judge by his last name. I mean, yeah, we used to do that as kids, like, hey, Murphy, pass the ball. But I don't know, I always see this where people, I feel like I've seen this lady before. Maybe I have, maybe I haven't. It's hard to tell, but I kind of recognize her and her mannerisms and stuff like that. But of course, as always, it's everybody else's fault. Now, if it was her versus one person or a couple or something, I'd say, maybe there's something going on there. But a whole bunch of people and all of them are to blame? Nah. Anyway, folks, I hope you enjoyed the video. If you did, make sure and smash that like button. We'll catch you in the next one. Sancha.
Thank you. Is Masika Willis present?
Yeah. Yes, Your Honor, I am here. Good morning, afternoon.
Good afternoon.
Masika Willis.
Thank you. And have the two of you had a chance to talk today?
We have, Your Honor. It doesn't appear there's really any dispute over what's owed, which including court costs as of today, and of course, May rent is going to be due tomorrow. But as of today, the amounts due are $4,000, includes court costs as well, filing and service fee, $4,527.54. My client is, given that there's no dispute, my client would request a judgment today for that amount with writ to issue on or after May 12th, which would be 10 days plus the weekend.
Your Honor.
Yes.
I tried to file that paper that said that I could get a 14.
So you tried to file it?
Yeah.
I'm sorry, I can't hear you. Why are you pressing buttons? I think that's making whatever worse. No, I can't hear you. Are you in the building? I can't hear a word you're saying, man.
Okay, I'm sorry about that. I tried to file that form, but I couldn't get to print my name onto the thing. So, but I did submit the that I do have help, and I did submit the T number for the application that I filled out. I was just trying to see if possible, if I could get that 14-day hold, because I am working with Section 8 right now to get my voucher reinstated. And I just gave her all the paperwork that she needed, and she should be back in her office on Wednesday. Tuesday she'll be able to look over my forms and get everything going. And then I also have another agency that's willing to help me pay for the remainder of the ballots that Section 8 won't pay for. I just needed a couple of more days if possible, just before the 10 days, because I'm not in I know it's not your fault or anyone else's fault, but I'm not in a position to just be able to move my family that quickly. And they are willing to help me. I just need a little more time, if possible.
Ma'am, unfortunately, the way it works, you have to either file the form and then you're entitled to the adjournment, or if it's not filed, they're entitled to a judgment. So I'm not understanding what the problem was with you filing the form.
The problem was with me filing the form, I had got the form via email, and it said to fill it out. I did all the legwork and getting the numbers and filing for the SCR. and all of that. But when I tried to fill the form out on my phone, I didn't know how to fill it out, like make the phone fillable, or I guess writable, and then resubmit it back to via email. That I was having to read.
Why didn't you come to the court and fill it out, ma'am?
I didn't know, I didn't have a way there. I didn't know that that's what I should have done. But I am right here at the library, and they said that they can help me complete the form and scan it, and then they'll send it back in for me. But I did
Who say is providing assistance to you?
I'm getting help from an agency downtown Ypsilanti. I think it's called Barmore or something like that. It's right downtown across from the bus station. They help people with these problems. And he said, he's going to help me with it. So I got to go finish that paperwork. I just need a couple more days in order to do that. And I'm just trying to see if I can get a little more time. And I'm at the library right now to submit that. They're going to help me print the form off. I fill it out and send it right back in. And I do have the T number that they requested for, to show that I am trying to get help.
You have the tracking number from?
Yes, I do.
Did you submit that to the court?
I did. I submitted that through the email, and that was the only way I just gave them the tracking number because I wasn't able to complete the actual form, but I did send in that tracking number through my email.
1 second.
I'm sorry.
I said 1 second, please.
Okay.
All right, I'm gonna find out whether she submitted the tracking number to the staff.
I think I can tell you the email. Let me look at the email here.
Ma'am, you don't need to tell me the email. I need to know whether they have it or not.
Okay.
So,
Okay. All right.
all right, I'm gonna pass this to hear back from my staff. Are we paper back in your bag? Are we ready on the Roshana Collins matter yet? Fine, I don't need to pass that out. We did get a tracking number for her. So, Mr. Carpenter, I feel like she's substantially in compliance.
Roshana Collins is mine, Your Honor. Is that Lake Point?
Yes.
Yeah, Robert Visconti for the plaintiff. So you did get a tracking number and you verified it?
No, it's not yours. No, I'm sorry, it's not Collins. It's Masika Willis. I'm sorry.
Oh, okay. That's a different one. Thank you.
All I can say, Your Honor, is I'm not sure when she submitted it. She certainly didn't provide it to me or my client.
I didn't know I thought I just had to apply it to the court. I didn't know I needed to give it to you.
And understand, Your Honor, though it's not completely relevant to the proceedings, it's not just the misrent that my client is having problems with the defendant. It's the fact that damage is continuously happening to this property. So, I mean, if you're going to adjourn it, I would ask for as short of adjournment as possible. I think it's
what type of damages are you? What's going on?
broken. My client can speak more to that directly, but I know there's been some broken windows and some other things, damages and miskeep of the property.
That window had got broken by accident. I gave the landlord $500 towards that window.
Ma'am, 1 moment, please. Okay?
Okay, I'm sorry, Your Honor.
Um, Sir, you can speak regarding damages that you have going on. Mr. Francis,
Can you hear me, Your Honor?
I can now, yes.
Yeah, I mean, we have the house re-inspected now a couple of times, and I'm constantly repairing stuff. Like example, even with the window, within that week of removing the window to get repaired, within that week, there's 2-bedroom doors basically ripped off the hinges, more holes in the walls. They had a dog in the bedroom, which I asked to be removed. I have got pictures of 9 feces of the dog in the bedroom, dog urine all over the floor, which is a mixed pit bull, which I don't like those type of animals. And again, like as far as goes, that the toilet was deliberately or clogged. I had to remove because they couldn't use it. I have pictures of that, and it's just constantly, every time I go there, I'm fixing stuff. Even with one of my previous inspections, I was there the day before, and the day of the inspection, the sons had kicked in the bedroom door. The day of my inspection, this is why I want the family to be removed. I can't keep up with the repairs. And as far as goes to the window, the glass was lying on the ground. Mrs. Wallace was home for over 10 days from her treatment program. Just lying on the porch, broken glass. I mean, that's a liability for me. And I don't need, I've tried to work with Mrs. Wallace over the years, and it's got to the stage where I can't do it no more. Before she went into the treatment program back in August of 2024, she was meant to be moving, and she hasn't tried to move, and the bills are just keep going up, and the damages, and I'm tired of the township keep calling me about complaints. And this is why the reason I want Mrs. Wallace to be removed from the property. I can't do it no more. I'm just at the stage where I cannot take this anymore. I mean, I've tried to work with Miss Wallace over the years, and I'm at the stage where I'm done. I can't do it. I can't go and fix stuff and have an inspection and stuff broke the same day or the day after. It's not going to be tolerated anymore.
Thank you so much. All right. So I do find that she's in compliance, but this is how I'm gonna handle this.
The 5th, the 25 ain't coming,
No,
down here.
all right, this is what I'm gonna do. I'm gonna grant the judgment today, but I'm gonna give her an extra 7 days to get it taken care of so we can have some closure to this. She said she needed a few more days from whoever is supposed to be paying on her behalf. So you were giving her until the 12th, and I'm gonna give her until the 19th.
Thank you. Your Honor, what I will say also is that my client did request a supplemental money judgment. Miss Willis was personally served. We'd like that included in the judgment, which would also include May rent, which is going to be due within that time, both to retain possession and in the money judgment.
I'm not willing to do a money judgment today. If you want to do that, then I'm going to grant the week, and we can come back and see where she is with payment on this. So
I'll leave that to Mr. Quigg. But we just as a matter of procedure, we did pay for a money judgment. She was personally served.
then I would give that to you next week. That's why I'm saying I'm willing to do that next week, but I'm not going to do that today.
Francis, what's your pleasure?
That's okay. Next week's fine.
Next week's fine. We'll just come back next week. Okay. May 7th, and that will be at the same time at 1:30 p.m. Ma'am?
Oh, I misunderstood that, Your Honor. So next week, May 7th, she has to have the money paid?
No, next week on May 7th, if you ask for a judgment, I will give you a judgment and a money damages judgment at that time. But because she's in substantial compliance with filing the documentation that would give her an adjournment, I'm going to give her at least that 1 week to get that done to see if they're going to pay the monies for her. So she has an SER application, and I'm going to give her a chance to see whether they're going to give her those funds.
Okay.
Okay.
Thank you, Your Honor.
May 7th, and I'll do it at the same time at 1:30. Ma'am, I'm not going to give any further adjournments after next week. Do you understand?
I understand, Your Honor. So so I have until when to get all the money in?
I haven't ruled on that part yet, ma'am.
Okay, but yeah, thank you, Your Honor, and I understand about that. Thank you.
You're welcome.
Have a good day.
You too.
Bye-bye.
Azara Stafford.
Your interpretation. In this case.
Your Honor, I'm not quite sure. Last time we appeared in the court had advised the parties to reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this instance.
The problem is, and I don't. Okay. You've not received any documents that you attempted?
Nothing since the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been filed by the defendant in this case, because she had changed the caption. They were to be refiled and served.
They were not.
Was that done?
Yes,
Was that done?
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court, we did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received, he has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
We'll try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption and serve them on opposing counsel.
Yes,
my sole question to you is,
okay.
Did you do that?
Yes, Your Honor.
Did we get a new filing? Yeah, because if she filed them and served them, they would be in my court file. And it's odd, I don't see new filings in my court file. And I don't see, and counsel's indicating he didn't get it, but she's telling me she didn't.
according to JIS, today an answer and motion to dismiss was filed.
That was,
Not by me, Your Honor.
yes, okay, I see that, but that was not the original.
I have not seen that.
Service on here, I don't. I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead. We did the same thing we did the last time.
And may I show this to you?
No,
This,
you did the same thing.
no, this notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case?
That was
And not sign it?
I'm sorry.
You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
I am a counter plaintiff, Your Honor.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go on.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to.
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I'm not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney.
Okay.
That's licensed to practice
Okay.
to do this.
Okay. Could we have next hearing after April 1st, please?
I'm not going out that far.
Your Honor, this is the third appearance in this case.
Oh, I know.
You gave her 2 weeks after the last appearance.
To get everything right.
And you admonished her to get an attorney at that point.
I did.
Yes.
Striking those pleadings. Don't file anything else that's improper and not properly filed with this court. I'm just going to be that direct.
Good.
adjourned to March 21st, 2020.
If I may, Your Honor, briefly, just briefly. This is not a rent case, Your Honor. This is
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak, and we need.
What way?
There's significant runoff and sediment runoff. The backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time. The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than an opportunity. She's filed this federal suit. She's doing everything possible to delay our occupancy, and I just don't think it's equitable or right. It's up, of course, your decision, Judge.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in the incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And I'm just, they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started. If at all the court would go along with us, let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment. And then she can do what she's going to do anyway when she gets her day in court, according to her. She's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
3 different, yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I'm going to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. His client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was owning this place in last 9 months, the Barton Village put a lien on the property. Now we cannot get a mortgage because they have a lien on the property. And by him in this court trying to put me down because I'm representing myself is also another violation of
No, you need to talk to me.
Yes.
Go ahead.
Okay. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay. I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy. Okay? This loan shark and his attorney are trying to,
Are you almost done?
yes,
Good.
to take us out of our home. And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property because it has a loan. Now he's asking us for the possession. We paid the rent, but the rental agreement is over. We want to buy the house. The lien doesn't let us buy the house, Your Honor.
I would ask for one brief moment to respond to that. If the court wishes.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond. And now you want to go back and guys want to spend all day going back and forth. Tell you what, you can put you over there on the side. I can handle all these other people's cases so they don't have to sit through this. I'm required to. And you guys can just go back and forth, and then I'm going to do what I was going to do 5 minutes ago.
Thank you, Judge.
Okay.
Hearing nothing else, March 21st, 2025, 2 p.m. You get the pleadings right or get an attorney in here. Thank you.
Thank you, Judge.
Ma'am, you're not going to yell when you're in here. You're not going to whisper under your voice. I don't operate that way. Understood? No. Understood. I heard you all the way up here. Have a great weekend.
You too, sir.
Thank you, Judge.
Can you do me a favor? Can you go out there and just make sure they don't like? I don't want to call anymore. I'm done. I'm so done. Yeah, here, you take it. All right, let's try this one. I can't let you have it if you're not gonna be unbiased. All right. Danetta Masick versus Lula Williams.
Hello, everybody, and welcome back. I still have decided not to go on camera because I currently still look like death warmed up. I am almost out of the woods in being sick, but still not feeling 100% and not looking my usual best. So yeah, here's an image on the screen of me looking real pretty a couple of days ago. But anyway, lads and lassies, I've got a very interesting one for you here today. This lady's in court now. She doesn't appear on camera, but she is in the background talking now. I'm just going to give you a heads up. There's a lot of background noise from her and kids screaming and stuff like that, and the judge has some stuff to say. Basically, this woman, to narrow it down to a very fine point, thinks that she shouldn't have to pay rent because she's got a leaky faucet. That's a tap for us here on this side of the planet, a tap. Anyway, so because of this leaky tap faucet, she thinks that she basically can squat there forever. She argues with the judge, and the judge is basically like, that's not the law. And she's like, Your Honor, as I'm sure you're aware. And the judge is like, no, I'm not, because that is not the law. But anyway, lads and lassies, I hope you enjoyed this video. If you do, make sure and give it a thumbs up, and we'll catch you in the next one.
Good afternoon. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. The court will call the matter of the Ranches of Rosebrook versus Anise Battle, case number 25C 1245.
Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Ms. Battle, could you please state your name?
Battle.
I'm sorry, could you repeat that?
My name is Denise Battle.
Thank you so much, Ms. Battle. All right, today's the time scheduled for a hearing in this matter. This is an action to terminate the tenancy based on non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified petition in emergency motion for injunction in the U.S. District Court, which is the case number 25-CV-11233.
Thank you, Ms. Snyder.
And like I said, this court has not put on the record of their jurisdiction. There's nothing on the record, and it stands. Every notice that I've sent is unrebutted, which stands at law. And jurisdiction is a threshold issue that we shouldn't even made it this far without discussing proper jurisdiction.
All right. Anything else, Ms. Battle?
As of right now, no.
Okay, thank you.
But I object to these proceedings in jurisdiction, subject matter
All right.
and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction. Mr. Fantera, and Ms. Battle, do either of
The
you
court
have?
cannot, I object. The court
Ma'am?
cannot declare its own jurisdiction
If
to
you
a sponsor.
if you keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers to throw you in jail.
I interrupted you. Okay, that's all.
Your Honor, I want to point out also that Judge Vandenberg actually addressed this issue last Wednesday and said that the 14B District Court and Your Honor does have jurisdiction over this matter. So not that it needed to
May
do
I
that.
add, Your Honor? Yeah. She also said that she was not aware of the things going on, so she just went on for anything based on what he just said. She said any law nor facts, just as you don't, of why you have jurisdiction. And it's no order that has it back yet, to be clear.
All right, thank you. Again, Ms. Battle, this court has jurisdiction and we will be proceeding today. Mr. Fantera, if you, well, actually, the both of you have an opportunity at this time to do any opening argument that you want to make. So, Mr. Fantera, I will start with you. Do you have an opening statement?
I'll waive my opening statement, Your Honor, and just get right to the evidence.
All right. With respect to service, can you please put on the proofs regarding the service in case there's an appeal?
Say that again, Your Honor.
Can you please put on proofs regarding service in the event that there is an appeal?
Mean service of this lawsuit?
Yes, on Ms. Battle.
I believe that she was served by a court officer with Jimmy Moore's office, Your Honor. I think there's a proof of service in the file. I don't know whether it was attached or whether it was personally served. But the court has the proof of service.
With respect to proof of service, the file indicates that Ms. Battle was served with two different ways pursuant to MCR 4.201B, which is she was served, actually three different ways. She was served with an original mailing from the court, and then a second mailing went out from the court. Second mailing was requested by the plaintiff and was sent by this court. On March 28th, there was a mailing. And then there was service by Edward Cope, who was the court officer. That service was effectuated through securing an attachment to the main entrance of the tenant's dwelling unit. And that was done on April 4th, 2025. And after attempts had been made on April 2nd at 12:40, and then April 3rd at 9:53, they finally did an attachment on April 4th at 4:30 p.m. In addition to that, Ms. Battle showed up to the court on April 9th, 2025 before the magistrate, therefore acknowledging that she had received service in this matter and that service had been perfected. Right. With respect to jurisdiction, we addressed that at the last court hearing. This is in Russell Court, which is within the jurisdiction of Ypsilanti Township. I think you hung up.
Your Honor, when she comes back, can we require her to, she appeared the last 2 times with a video. Can we require her to have video today?
Ms. Battle, are you back?
Yeah, we were disconnected.
Yes, Ms. Battle, you're back. All right,
Yeah.
what request were you making, Mr. Fantier?
I know the last 2 times that Ms. Battle has appeared, she appeared with a video, and this time she's just on her phone. Can we require her to be here by video today also?
I would have had to give
Well,
her.
the thing is like I tried to tell you all last time that the time was bad. This is when I pick up my kids.
All
So
right,
if we
then
can
we
do
can
it
just-
like earlier or something of that nature, yeah, that's fine.
Then I'm okay just proceeding as long as the court is comfortable that we can swear her in when she goes to testify.
Thank you. I am comfortable. I can tell you that if I was going to require that she be here via video, I would need to give her notice of that prior to today's date. So I'm comfortable proceeding as we are.
Okay.
All right. And Ms. Battle, other than jurisdiction which has been noted and reserved, do you have any other argument you want to make today with respect to this matter in terms of an opening argument?
Of course. So like I said, the contract has been rescinded on April 1st, and it was due to unconscionable pieces in the contract, including pieces that's wrong with the formation, as well as material breaches that's inside the contract. That contract has not been
You said
material
material
breaches.
Oh, okay, go ahead.
Breaches, yes, within the contract as well. That was sent out and received. Well, it actually wasn't received on April 1st because at the end of the day, the unconscionable pieces, their addresses are wrong and the owners are wrong on the contract, so it got sent back. But once I realized it was sent and received on April 8th, 2015, and still remains unrebutted. They have yet to unrebut it in any case that we came and talked about the contract. And by law, according to Wall versus Zendaya, the Michigan law recognizes rescissions at common law for breach, fraud, and unconscionability. Meaning, if I give notice and it's unrebutted, that stands at law. Also, I've talked on personal matter jurisdiction, in which why I came in under special appearance the first 2 hearings, because at the end of the day, I'm not a legal person. I'm not in a legal capacity under Michigan law. I do not qualify as that person, which that person is a corporation, a trust, individual, in some type of legal entity of that nature, an association. I do not qualify as one of those people to be here and subjected to this without consent. Hence why, things were sent administratively and defaults were given administratively, because things are happening right here where I'm being deprived of due process, and I should be awarded due process by law. As the attorney stated last time we were here, he was saying that basically the burden of proof only applies in criminal cases, which is false, because the burden of proof applies in all civil cases where jurisdiction or contract validity challenged, and that's Taylor versus Bullam in 1992 in Michigan. You still have the burden of proof. The court cannot establish their own jurisdiction being based on a contract is rescinded. You have to have a valid contract to come into court about. So that's where your jurisdiction of the subject matter is at hand, because the contract is rescinded, not unilaterally, like he's tried to claim before. It is rescinded, meaning I gave you notice and it's unrebutted, just as if somebody came into the courtroom for an eviction, or if they did not come for the eviction, you'll give them a default, because what happens at law, your silence stands.
All right, thank you, Ms. Battle. Mr. Fantera, you may proceed with your case.
Plaintiff would like to call Dawn Charles as a witness.
All right, Ms. Charles, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing.
I do.
Thank you. You may lower your hand. You may proceed.
Ms. Charles, please state your name for the record.
Dawn Charles.
And what is your position with the Ranches of Rosebrook?
I'm the property manager.
Are you familiar with the tenancy of Anise Battle?
I am.
Are you familiar with the lease agreement that that she signed?
I am.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024. I'd be moving for that to be admitted as Plaintiff's Exhibit 1.
Did you also provide a copy to the defendant?
I did not, because I do not have her email address. But she should, Your Honor, I should say for the record, she should have a copy of the lease because it is, because she signed it.
Any objection?
I never received a hard copy of the lease, and I've asked for a hard copy of the lease. Never received it, and as I read the lease, that was also a breach of my lease, as I was supposed to receive it and sign it in person, as they made me sign it over online. So again, the information that he's saying about the lease is correct. I'm not here to argue about the lease as far as what the original contract was. I'm arguing about the validity of what it is now, which is invalid and void because it's been rescinded.
Thank you.
And unrebutted.
All right, given that she's not arguing about the validity of the lease itself, I will allow the exhibit.
No, I've said I did argue about the validity of the lease as far as it being valid, because it's not. But I'm not arguing that I entered into a lease on or around December 6th. That's not what I'm arguing. I'm arguing the validity of the lease. So let's correct that.
You're arguing, you're not arguing that you entered into the, what are you arguing?
Like I said, I do not object to actually entering into a lease. What I thought was, yes, a proper lease or on or around December 6th. I do not deny that, but I do deny the validity of the lease because the lease has been rescinded and it's unconscionable. Yes.
Thank you. Her argument, as the objection in this case is that the lease is rescinded and therefore it's not allowed to be admitted. That is overruled and it will be admitted.
Hold on, 1 second. Hold on. Y'all gotta. Everybody be quiet. I'm sorry, I didn't hear you, Judge.
I said that your argument that the lease is rescinded is not being admitted. The lease is admitted. That objection is overruled.
On what facts of law?
The fact that I just ruled that, ma'am.
That's not a fact or a law. So let the record show that he has no proof.
The record
no
shows
law or no merit to
everything. The record shows everything, ma'am. You don't need to say that. And please stop.
I know it will when I pull the transcript, because like I said, this case is also.
All right, Mr. Fantera, you may proceed.
Okay, I want the record to show that I find it unfair that you can cut me off and use my mic whenever you feel like it, but I can't talk and have a fair hearing.
You're going to be held in contempt of court and you're going to do jail time. Mr. Fantera, please proceed.
Ms. Charles, can you, under the terms of the lease, what is Ms. Battle's monthly rent?
$1,075.
$1,075?
Correct.
Does she also have to pay utilities?
Water and sewer.
So for what months has she not paid her rent?
March, April, and now May.
So she owes $1,075 for each of those 3 months.
Correct.
Has she Does she owe the water and sewer for those 3 months also?
Yes.
How much does she owe for those months?
Her water and sewer.
Yes.
So March is 36.24.
April,
35.45.
May,
35.73.
okay. That totals 107.42, correct?
Correct.
Are there late fees under her lease?
There are
What is the late fee?
$50.
On what day?
The 6th.
And so she's being charged a late fee for March and April, correct?
Correct.
So the total amount that she owes is $3,225 in rent, $107.42 in utilities, which is also rent, $100 in late fees, and then she would owe the court costs of this in this matter, correct?
Correct.
Have you reviewed the work orders that have been submitted by Ms. Battle since she has been a tenant?
Yes, I have.
Are you comfortable that they were all completed in a timely fashion?
Yes.
No further questions, Your Honor.
Thank you. Ms. Battle, do you have questions for Ms. Charles?
Yes, I do. So the first working order, are you able to disclose, or do you know firsthand what that was?
Your first work order was your shower water wasn't hot. You had some screws in your hinges that weren't secure. And when the water was turned on in the tub, it comes out of the shower as well.
Okay. So how do you define complete? How is that work order complete?
Well, that was the work order you put in. The notes for repair are that the diverter for your hot water was repaired. Our construction company fixed the tub faucet that had came off, and we installed new screws in hinges on the door.
Right. So do you have anything that the actual construction company came, because nobody came? Because even if you go on to the next 3 orders, that's also listed as an issue because it was never addressed.
Well, the next work order after that
correct?
was actually December 26th, and it says the door that was repaired, the screws were still not right, so we put new screws in it. So that wasn't a work order about the tub. The one after that was January 28th, and that was about hearing animals in the attic, and we installed new soffit and made sure nothing was in there. There was also one on January 27th. We adjusted your shower head and plunged your toilet and tightened a basket on your sink. There was one on February 14th that your tub was not draining and water was coming out of the faucet. We unclogged the tub and the shower head was working properly. And the last one was March 17th that your furnace was cutting on and off. And we took your furnace apart and checked all the fuses and put it back together, and it was up and operating properly.
Okay, so let's go into that more, because we might even have to subpoena the maintenance man, because this is going to become an issue. So when you say that you came into my bathroom and screwed the shower head, what would be your purpose of doing that? Because what was my request? My request was that it was still, the water was still coming out of both faucets at the same time, which have not been correct because you have not gotten a contractor out here. A contractor has not came out to my house about that. And let's go on to the heat, right?
Miss Battle.
I'm sorry.
You can't testify now. You can ask her questions. You will get a chance.
Okay, I'm gonna ask her a
was
question.
in
You're right.
the apartment between December 15th and 16th because the
Wait a
work
second.
order was
Wait,
closed.
no, everybody stop.
Wait.
There's no question
You
on
said I
this.
had to form it as a question. I apologize.
Okay, go ahead, Miss Battle.
Okay. So you're saying that a contractor came out You said December 16th?
Correct.
And what contractor was that? The contractor that did the job?
Correct.
Okay. And when that contractor came out, what did they say that they did?
Repaired the tub faucet that had came off and repaired the tub diverter.
They repaired the what that came off?
The faucet for the tub.
One more time.
And the diverter for the water.
Right. Okay. So let that address that the faucet pushing out and the diverter, that doesn't address the issue of the plumbing, which really, when I had somebody come out, they said the wall has to be taken down because what happened is they messed up behind it. So again, let's rephrase, let's go on to the new one. Let's go on to the furnace. So when they came out for the furnace and they came out to fix it the first time, what were their results from that?
I only have one work order for your furnace. They took it apart, checked the fuse, put it back together, and it was up and running. They cleaned it and put it back together.
Okay.
The furnace is new.
So no, it was two work orders. One was done in the middle of the night. I'm in the morning before they came into work. So I just wanted to be clear. So you don't have that work order for the morning? I'm asking the question.
1 second, there's an objection.
Your Honor,
oh, you said it was an objection?
Can you listen to it, Ms. Battle?
I can hear him now. You say he had an objection?
Your Honor, I want to object. We're getting into the weeds here. I mean, you don't have a right to withhold rent or rescind a lease because of something small such as a tub faucet. And so, we're getting into whether somebody actually came out and fixed it or when it got fixed. And it just seems to me that this is irrelevant to the proceeding that's going on today.
Well, it's object because it's not irrelevant to the proceeding because it's part of the reason on why I caught up the breach, because at the end of the day, I kept trying to get somebody to come out to fix these things that are not fixed. Heat is a major thing. It's been cold. I still have a heater in my house because they haven't came back and got it and fixed it like they said they were going to. You get what I'm saying? It's still unconscionable things in the lease regardless. So everything about what I am arguing here is valid because I do have the right to rescind the contract based on breaches of the contract, just like you can come here on a quote unquote breach of the contract. It's the same thing. Why do I not get the same right and to hear what's going on so she can hear what's going on?
Your Honor, we will be more than happy to, the purpose of rescission, as the court knows, is to put the parties back in the same position they were before the contract got entered into. We will be more than happy to rescind this contract and basically have Miss Battle pay what she owes through the date of move out and terminate it so she doesn't have any more rent owing after move out. The problem is what she said to Judge Vandenberg last week, and I believe what she believes, is that when something gets rescinded, she is allowed to live there until she finds a new place. And that is not the law. We are more than happy to rescind this, to do away with this contract, let her pay her balance through the date of move out and terminate this contract so that she can move on and we can move on. But what we can't let her do is to live there forever without paying rent.
Well, let it show that by law, by contract law, if the breach is on your end, if you want to comply to it, like I said, because I did rescind it, and the breach was on your end, and it's rebutted on your end. And by law, under the landlord and tenant, it is called constructive possession. When you are in breach of a contract and I'm not at fault, I am allowed under equity and law to stay in a place. It's called constructive possession. Constructive possession. The breach is not on my end. It was on your end.
Miss Battle, that's not the law, ma'am. That is not the law. Absolutely not at all. And ma'am.
Okay, so then if that's the case, if he wants to call out the breach of contract, then he's making it an uneven deal. Okay, so if he wants to say that he wants to accept the breach, then he has to accept the damages that come behind it. Because there's damages if I have to relocate on something that's not based on me. That's unfair, and that is that's unfair in bad faith.
Your Honor, I'm not trying to be unfair. All I'm trying to say
The
is
breach is not on me. The breach isn't on me. So if the breach is on me, I will understand what you're saying completely. The breach is not on me, so I should not be held liable for y'all breach.
yeah, but you're the one that wants to, Your Honor, but she is the one that wants to rescind. So it seems to me that she can't have.
I want to rescind based on the unconscionable contract. And what does my rescission also say? If it says it, if that's the case, if you all want me to leave and you don't want me to have the constructive possession, then you all should be paying for my relocation because it was your injury to me.
Can I say something without being interrupted, please?
I want you both to stop talking for a minute, please.
Go ahead. I'm sorry.
So, first of all, if you want to talk about whether a contract can be rescinded, that is not typically what happens in a landlord-tenant. That's in a standard contract situation. However, if there is, in fact, a situation where capital is for you to get some of your monies back. That's not something where you get to just rescind the contract. That's why all of this is the wrong procedure. However, Mr.
I'm sorry.
Please. Mr.
You
Fantera.
were saying something about getting your money. I need you to go back a little bit. It's breaking up really, really bad.
So you're entitled,
I can't hear you clearly.
if in fact the court were to find that, for instance, the property was not habitable, like there were enough repairs that were done so that the property was habitable. We're not going to be able to make this out because of the children in the back. My recorder is saying she can't make it out.
I'm trying to make it out too, and it's just like breaking up a little bit. That's why I tried to tell y'all that this was not like a good time for me at all. Remember, you had got his time, and when I went to go say my time, you cut my mic off, and I was literally trying to tell you that I cannot. It's 3 o'clock is just not a good time. I'm getting my kids out of school. I don't have help when it comes to getting my kids out of school. So, yeah, but we can continue to try. We can just try to go for a morning time. I can do morning time.
I have on the mornings. You don't have to figure this out. And if you don't figure it out, then the repercussions will be against you. You're gonna have to figure it out.
Well, hold on. I am trying to figure it out. I wouldn't be here if I wasn't trying to figure it out, or if I wasn't trying to,
I grant you that. I agree with that. I agree with that. But I have criminal dockets every morning. We don't have morning docket.
You said what about a warning? Hey, stop. Hey. You said what about a warning?
I said we have criminal dockets in the morning, ma'am. Is what I said.
Yeah, I can do it in the morning.
That's not what I said.
Oh, I'm sorry. I'm sorry.
Hold on.
Hello? Y'all can't be that loud. No, hush. Leah, for real.
Mr. Fantera, this is not working. It can't be recorded properly because of the background noise. I can't finish this today. Are you available on the 16th at 9 in the morning?
I am, make sure my witnesses are Dawn.
Yep.
Ms. Battle, are you available at 9 in the morning on February 16th?
May 16th, Your Honor.
May 16th. I'm sorry, I'm discombobulated.
Yes, 9
a.m. works?
Yes, 9 a.m. is perfect.
16th at 9. We'll be back here again.
Your Honor, can we require, since I asked before and you said you didn't give notice, her to be by video Zoom?
Yes, Ms. Battle, can you come via video Zoom, please? Ms. Battle, you're muted.
I'm sorry. I keep trying to mute it because I think that's why I keep muting me because it's my background. But I said yes, that's fine.
Okay, thank you. I appreciate it.
And I will also mail copies of all of the exhibits that I submitted to the court to Ms. Battle so that she has them beforehand.
Thank you. We'll see y'all.
I appreciate it, David.
See y'all May 16th at 9 a.m.
Okay. Thank you.
Oh, the entitlement is strong today. We have another one here today. Another really entitled lady who has a bit of a conniption because she doesn't get her own way. She said the judge said some stuff. He said he didn't. He said, she said, whatever. Fact of the matter is he's made his order and she's not happy about it. Let me know what you think in the comment section down below. We'll catch you at the end.
And this matter comes before the court today on Mr. Beeson's request to withdraw his counsel in this matter. That is also supported by a certified or a notarized letter I received from Miss McKaylee requesting new counsel due to a breakdown in the relationship. I would invite counsel, will you please place your appearances on the record at this time?
Tiffany Burks on behalf of the people.
And Mr. Beeson, you're muted.
Sorry. John Beeson, Your Honor.
Thank you, Mr. Beeson. Anything to add to the motion, Mr. Beeson?
No, Your Honor. Ms. McCauley is present, but she has her audio on.
Yes, no, that's fine. Any position from the people on the motion to withdraw his counsel?
No, Your Honor.
All right. Well, in that case, I will grant a motion to withdraw because Ms. McKaylee has indicated a breakdown in the relationship. And Ms. McKaylee, is it your intention at this point to request appointed counsel, or are you going to hire new counsel on your own?
This is a motion for me to get off probation, right?
I think there also is a motion to terminate probation in here. You know what? Let me handle the counsel one first so we can determine whether you're supposed to speak on your own behalf for probation. I had two motions, Mr. Beeson's motion to withdraw, and then also, yes, you're correct. Your next one up is yours to get from probation. So, what's your intention going forward with regard to an attorney?
I do not wish to have Mr. Beeson represent me, Your Honor. I made it clear to Mr. Beeson that I did not wish to sign a waiver, and he manipulated me into signing the waiver, did not give me a copy, and I had to obtain a copy of that waiver, which is why my case was bonded over. It has also been on my record that I have absconded for 2 years, and I've never ran. This is a major problem. It has stopped me from being able to better myself, Your Honor. I am very frustrated. I don't owe you guys anything. I don't owe you guys any community service, any money, and I am still being punished.
All
Your
right.
Honor, may I address that real quickly? Just so there's a clear
Mr.
record.
Beeson.
The record is, I have nothing to do with her previous, whether or not she has a notice on her file about fleeing. That was my concern. Secondly, Judge found over Miss Cawley from the prelim, she signed a circuit court waiver. Her case is already bound over. And I explained to her that by signing the document, she did not have to attend in person for the plea not guilty in front of the circuit court judge. So I don't know if she understood that or not, but you can clearly see there's a breakdown. So I asked the court to grant my motion.
Yep, no, I can see the breakdown in the relationship. I will grant the motion and allow your withdrawal at this time, Mr. Beeson. And I'll ask you, Ms. McKaylee, is it your intention to hire a new attorney, or would you like me to appoint an attorney or have the defender's office assign an attorney to represent you at this time at no charge?
No, I would like to get this motion going. I don't need an attorney. I'm not.
Yeah, I'll continue with your motion today. I'm just thinking going forward. And is this the only thing you're in front of me on, or is there? Because my review of the case indicates there might be another case coming here.
Yeah, May 13th, the driving while intoxicated was bonded over for May 13th in front of you. Also,
Okay. Who's representing you on that one, Miss McKaylee?
I am currently looking for someone to represent me. I have a lot of support. I am in the FIT program, and we are looking for an attorney to represent me in this situation. Also, to take care of that absconding that was on my record. That has really put me in a bad situation.
Okay. All right. Well, what I have here is I extended, let's see, probation here for 90 days because of that OWI that was pending in 61st and has now been bound over and will be in front of me in May. And I amended the discharge date from probation to August 23rd of this year based on that. And, based on the additional charge to OWI, I don't see any alternative here but to keep you on probation for that time. Are you still wearing the scram, Miss McKay?
I am, Your Honor, and I have been wearing it since November. I have no problem with wearing the scram. I'm a cosmetology school because I tried to take CNA and I was denied because I was listed as absconded 2 for 2 years, which
Yeah,
makes
no,
my
I
guidelines
do.
go up, which is a major problem and it's not being acknowledged. So I need an attorney behind all of this stuff that's going on. The amended sentence was not represented to me. When it was represented to me, it was represented to me first without a signature by you. It's just been, I haven't got anything in the mail. It's
Do
been a
we
lot.
have a good mailing address for you, Miss McKaylee?
Yes, you guys have.
Okay, yep, that is what we show in the court record here. So that is good. We're at least sending stuff to the right location. What I will do, well, in the meantime, prior to that conference, and Mr. Beeson has represented you on that case up until this point. Now you don't have an attorney. What I will do is direct you to obtain an attorney within the next 2 weeks. Because we determined that conference you said is coming up on May the 13th. Yeah, so that's 2 weeks is just going to put you a week before that. If you don't have an attorney prior to that date, what I will do is I will appoint a court-appointed attorney to represent you, so you have representation at that hearing. So today's order, though I'm going to keep you on probation, it will direct you to obtain counsel on the new case of your choice within 2 weeks, which would make it by, let's see here, May the 7th, or I'll appoint counsel.
Your Honor, this case has been pushed out and it is hindering me. You guys extended my probation past my max date.
Nope, I did, but given the
for 60 days, you did it for 6 months.
Yep, well, and given the circumstances, when I have because I do have you on probation, for OWI, and if that ever happens and I get someone else that picks up another OWI charge, I keep them. I'm not treating you differently than I treat anyone else. I do keep folks on probation, and it's mainly because I want to be able to monitor whether you're drinking and driving during the probationary period. If you were, then I would take the additional step of holding you in jail. You're not indicating any of those problems, and the scram, as far as I know, has been good for you. So I mean that you've been compliant with the scram conditions, which is a good thing. That gives me the assurance that the public's safe while you're out there while we get the new case worked out. So that's all information I can give you.
Judge Rossi, you also told me that you were going to release me from probation back in September, and that did not happen. Like, I am getting the runaround with you guys, and I do not feel like this has been fair. I am not disrespectful, so I'm not going to question your authority during court. If you tell me something that you're going to do, that's what I expect. That was supposed to be done before this event even occurred. The reckless driving was thrown out, so I don't even know why you guys would be coming at me for a DUI.
Okay, yeah, well, the indicator I have here is that it's a reckless and an OWI in the 61st District Court. Is that what or did you just get bound over on the reckless?
I didn't get bonded. The reckless was dismissed.
I
With
see. Oh, but I
prejudice.
still have the OWI coming in front.
Right.
Yeah, no, and that's the more serious thing, and that's what's going to require, to be addressed by your lawyer.
Your Honor, you got, I wasn't driving, so this is just hindering my life.
No, I get it. And I understand that pending charges and the absconding charge and all of those things have a serious impact on your life. And my flip side of it is, I do apologize. I know it can feel like the system kind of pushes and moves you around without much regard to what's really happening out there. However, I can tell you, from my perspective, particularly with OWI cases, I am in favor of resolving them. However, I've got to look at the unique situation of the concern about public safety when I've got someone with OWI charges, because, as if you got behind the wheel drinking or having used something, as I describe it, it's like shooting a gun into a crowd. It could, you might not hurt anyone, but then again, you might kill someone, and it's just too much of a chance for me as a judge to take. So I've got to be extra cautious with OWI charges, and I always am. Just for the public safety aspect. So that's the best explanation I can give you at the moment. However, once we get an attorney and we get that status conference, we can address those things in front of me. I can advise you, if you plead guilty on another OWI charge, the likelihood is that you'll remain on probation for an additional 3 years. That's my policy, at least on every OWI third charge that comes in front of me. So just so you're, got some parameters to think about going forward. And like I say, if you're successful hiring a new attorney, have that attorney file an appearance. If I don't see an appearance by a week before that status conference, I'll send it over to the county and have an attorney appointed.
If I don't, if I'm not able to get counsel, I don't wish for nobody from the courts to represent me, Your Honor. I have no faith in you guys.
Well, and all I can tell you is those offices are independent, the defender's office and our court-appointed counsel list, other than the fact that I'm paid by the state of Michigan, but my staff and the rest of the court's paid for by the county, and, the defender system is also paid by the state of Michigan and the county. However, we don't have any control. They should be an independent advocate for you. In other words, they don't work for me. They're there to represent you in the system. So, and I can tell you, you'll be much better off going forward with an attorney than going forward on your own, because the attorneys do.
You guys don't have me driving. This case is pointless. It's just holding up my life. That's all it's doing.
Yeah, no, and that is very much the effect of this type of
You
charge.
guys extended my probation past my max date, and I don't
do.
owe you guys anything. I've done all my community service.
No, the number one concern here is the new charge. At this point, Ms. McKillian, we'll deal with that when I see you in May.
So the reckless driving, if they dismiss that, I don't understand why they're still pushing for the DUI.
Yep, that's a question for the prosecutor and for your attorney to discuss, either prior to that conference or at that conference. So, like I say, if you're successful hiring an attorney, have them file an appearance and they can get talking to the prosecutor's office. If not, I'll get someone appointed. The faster that happens, obviously, whether you hire an attorney or I appoint an attorney, the more communication they can have in advance of that conference to address your concerns.
So, okay, can you tell me about why you told me you were going to let me off probation and did not do it?
Well, I can't tell you exactly because I unfortunately don't remember every single thing I say when I'm
But it
in
should be
court.
on record, Your Honor. It should be on record. We did
Yeah,
that
no, and
before.
I
I
do have
lost
the
my
one.
job behind being on scram again, like I told you it was going to happen. And I lost my job and I was like, okay, that's fine. I got some health issues going on and I'm going to be off probation so I can just sit down and go to school. I could not do that because of the absconding.
Yeah. Well, and I know
Then
why I
when
put you on the scram was because the
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 violation.
violation, right? That I can tell you. But I can't say, yeah, and I can't
But you
say
didn't
that
take me off
obviously.
probation like you told me you would. You said if you do scram with no hiccups, I'm going to take you off. That did not happen.
And I had you on scram starting on March 8th, and you've been on now for. Well, that's March 8th. Oh, I see. Yeah, when did we put the scram on? You said November.
Scram this time since November. Before I got off scram in September and I was supposed to be let off of probation. That was what you told me in court. I told you I work at a medical factory and that I believe I will be let go because of this scram because it's a very conservative place. I was let go.
Yep.
When it came time for me to get off of scram off scram, I was told by Shannon that I'm not eligible to be let off of probation, which I don't understand why you would even tell me that.
Yep.
That
No,
feels as though it was to mislead me, so I would accept the scram. I did, which I've been on scram 4 or 5 times. I've never dropped dirty on scram.
yeah, no,
Never. I am
that's,
not being acknowledged for none of this time or none of this work that I'm putting in. My life is only being held up.
yeah, and I see what you're saying here because
I
you
put
started
myself
that
in treatment.
probation, looks like on February 23rd, 22. Well, and the other explanation as to why I would have
22.
not let you off. Well, that's when this case started, right? When I put you on probation in the first place. Would have been February
This case is
22.
from 2020. Actually, 2019 is when the case was.
Yeah,
When I
we probably entered the order, the plea resolving the case could have been 2022.
Okay, so what do I do about, I don't want to be disrespectful, but like, what do I do about you telling me one thing and that not happening?
Well, the only safe way, as I tell people in anything, is to have me reduce it to an order. There are two ways that can happen. I can do it on the record in court, and your attorney can obtain transcripts of what I say in court, and I do honor that. If I say it on the record in court, then I do follow what I said. And then second is, I do a written order. Sometimes your attorney will generate a written order for me to sign, and then we have it in the record. So then when I make a representation like that, and that again assumes nothing changed. And I look here and I say, well, what changed? And of course, the biggest change was you picked up that additional OWI.
That was 2 months after I was supposed to be already off.
Yeah, and I'm looking
And
at
it's not, I
this.
wasn't even driving. So it's just me being at a scene. You got my name coming up, and now because
Yep.
I have a history of DUI is really why I feel like you guys are coming after me. But that's personal feelings. And
Yeah,
I'm
well,
not
and I
gonna
don't make the charge decision. That's entirely the prosecutor's office, and then it gets in front of me, and they'll give you an evaluation based on the facts of the case. It doesn't just because you're charged with it does not mean, of course, that you'll ultimately be convicted of it. But while it is a pending charge, and because of the prior OWI, I need to be cautious and extend the probation.
But why didn't you follow your order of taking me off probation?
Well, I think the number one reason that I can give you on that was picking up that.
I didn't have a case when it
I
came
see.
time for
Right.
me
Well,
to get off probation.
your probation would have ended with the scram, is what you're saying. Well, and it's right
In
about
September.
right about the same time because I put you on scram
No.
November. You'd have been on there for at least a couple of months till January.
Well, I'm talking about September of 2024. I was supposed to be off of probation, off of scram, done. That was the agreement you told me in court. You said, I feel like it's necessary for you to do scram. I told you then I have done scram. I think then it was like 3 times. And I've never had no issue with scram. You said, well, you do scram this time and you have no hiccups. I am going to let you off probation. That did not happen. That was the first week of September when I questioned William Shannick about it because I was transferred back to him from Dominic Milton. He said, I remember the judge saying that in court, and he told me he was going to look into it. And then he said, oh, you're not eligible to be let off of probation early. So that's where my frustration come in at.
Yeah,
And
I
then
would
this case
understand it,
being
and
totally and it's like really holding up my life and stopping me from being able to better myself.
no, I get it, and all those are valid considerations. However, the only thing I can posit there is that what got in the middle of this is we were coming close to the time when you would have been eligible because of the expiration of the 3 years of I put everyone that's an OWI third on 3 years of probation. Sometimes I let people off 90 days early from probation when they have a good record, and that's what would have happened had you.
It didn't happen, is what I'm telling you. It didn't happen. This case is 2 months after I was supposed to be off of probation. You did not let me off.
Yeah, no, and the only thing I can tell you is what happened there is you picked up that.
Your Honor, I picked it up 2 months after you told me you were supposed to let me off probation.
Well, that was contingent on nothing else happening, and when you
I
pick
was
up a new
supposed to be
charge,
off, Your Honor. You keep saying it's because of this new case.
yeah,
I was supposed to be
no,
off September. This case was called at the end of October.
yeah,
And
I
like I
get
said,
it.
I wasn't driving. I went and hired an attorney. He did not do what I told him to do.
Well, and I don't have
I'm
any
really
facts
feeling like
about
I
that
need to
new
get
case.
other people involved because this is ridiculous. You guys have had me as absconded for 2 years. 2 years. I've been to jail. I've been in front of you. How is it possible?
Yep, and
I am pissed. I'm not even gonna lie because I am trying to be better. I am trying to better myself to be a good example for my children, to make my life more financially stable, and you guys are hindering me.
Well, and that I can certainly see how you'd have the feeling. However, I got to deal with the new charge that's in front of me, and that's what's gonna, kind of set the course
Well, I
for the
have to
next
go in
3
front of you.
years.
I don't see why you're keeping me, why you're denying my motion to be off probation. I
Yep,
have to go in
no,
front of you. You guys dismissed the reckless driving, so I don't know how you're going to give me with a driving period because I wasn't driving. I was
well,
with a
you're gonna have
licensed
to.
driver, wasn't in the car or nothing.
I can't weigh in on that because I don't know any of the facts of the new case, but you're gonna have to address that with your new attorney.
Okay,
Good luck to you, Miss McKaylee.
sure.
Well, there we have it. Sad to say, Shamika, you got what was coming to you, I think. What do you think? I really do want to hear what you have to say down below. We'll catch you in the next one, folks. Sláinte.
Mr. Benak, do you have a law degree?
No, I do not. I don't have to have a degree to stand to freedom of speech.
Waking up.
So, here you
Sitting
go.
there sleeping in a chair. Wake up, dude. You're about to get kicked out of your house. You've lived there for free for 2 years.
Yeah, now this one is about as weird gets. It seems like these people have been living in this house for close to 2 years, I think, without paying any rent whatsoever. The guy's argument is absolutely nuts. And yeah, the judge is well able for him. Surprise, surprise. So check this one out. Let me know in the comment section down below what you think, and we'll catch you at the end.
Here, you're fine.
All right.
Oh, you hear me good. Okay, sorry.
Okay. This is New Res LLC versus Jared Michael Benak on Electric Court in Sturgis. attorney Mirella Albu is here from the Trot and Trot Law Firm in Detroit on behalf of New Res LLC. This property was sold at a foreclosure action last August 22nd. And this probably has been in the works for several years. You have 180 days to vacate, or they can bring this action. They've waited well beyond that. And at this point, it's the bank or this New Res intentions to take possession of this property and probably sell it. What's your position, Mr. Benek?
Okay, the only position I really have is we started out, my son, I'm the father, and we started out with a payment plan with them at 3-point-something% rate interest. And they never told us anything. After about 2 years, it started going up and he got behind. It was like a taxi kid is kicked out. We couldn't pay. There's no way you could pay and keep up. And on top of it, he lost his job and he tried to fix all that too. So we went through a lot
So
of.
are you a co-signer for your son?
I'm just speaking for his behalf because and I'm really tired. I take care of most of the stuff in his house. He's like almost sleeping here in the chair. I can show you if you want to see him.
All right, just a minute. What's your name?
Michael Benek. I'm his father. I've talked to them before.
Just a minute. Mr. Benek, do you have a law degree?
No, I do not. I don't have to have a degree to stand to freedom of speech.
Wake him up. So, I don't need to talk to him. I need to talk to him.
Well, he would like to have a statement. I guess I can't speak in his behalf.
No, you can't. You need to have a law license to represent somebody in a legal action.
Well, I guess I'll have to go to court then, won't we? All I'm doing is just trying to tell him we're not fighting over the house.
All right, we already
have it signed. We don't care.
Let me talk about where we are here. Okay. Your son had a variable rate mortgage and his rent went up, or his payment went up, and he wasn't able to make it.
They doubled it.
This is my turn to talk. This is my turn to talk. So he hadn't made the payment probably in several years. Probably it wasn't made at all in 2024 and probably part of 2023. The house was foreclosed on last August. So this didn't sneak up and bite you in the ankle.
No, we didn't. But we didn't get any. We couldn't talk to him, sir.
You got a notice from the sheriff that your house had been foreclosed on. So they can't do it unless you get notice. They post it on there. So you've lived there at least since August, September, October, November, December, January, February, March, April, and soon to be May without making any payment. Yeah, so your son has the benefit of free housing. So I want to talk to him, or I'm going to default him. Sitting there sleeping in a chair. Wake up, dude. You're about to get kicked out of your house. Are you Jared Michael Benek?
Yes.
All right. The mortgage company wants your house back. And they have asked you to move. Have you made any provision to move?
I've been having a hard time getting money to move.
Yes, well, you've lived there for free for 2 years. So theoretically, no one does. You should have a big pile of money when you didn't make your house payment to move somewhere else. But this proceeding is an unpleasant one. It is what property owners and landlords do to get their tenant out. The tenant would never move otherwise. You've known since last August that they want you to move. We're now almost in May. So I have to continue this matter. I'm going to continue it to May 2nd at 3 o'clock. Does that work for you, Ms. Albu?
Yes, Your Honor.
All right. Now, this is the end of a long process. They had a sheriff's sale last August. And you had 180 days to redeem the property.
Is Abby
March, which would have been March. And now you haven't redeemed it, so they're asking you to move out. They want to take possession of the premises. So if they get what they asked for on May 2nd, I would order that you be out of the house by May 12th, which is 17 days from now.
Yeah.
All right, so we'll talk about this further. Now, I read the advice of rights, but you were sitting there in a chair. I don't know whether you were paying attention or not, but what I did say is you have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. So I sent you the information with legal aid's name and number on it. You could contact them. But I don't really know that you have a defense. You haven't made your payment. The bank foreclosed on it. 180 days passed and you didn't redeem it. And now they want the property back. And so it's a tough situation. We do this every Monday and Friday. And people are struggling. But have you made any effort to find a place to move to?
What do you ask?
Any effort to find a place.
No, we just started because we didn't get informed that they sold the house. I'm trying to tell you, there was no communication between these people. They came to our door and wanted to give us a paper to go to court here. It's the only time we ever spoke with them. But I mean, he doesn't know what to say. He's a young guy. I was helping him get the house. I use my own money. I'm going to die soon, so I don't care. But all we're trying to do is just leave the house. Give us 30 days or a little bit more, and we'll move. My daughter was buying the house.
We can talk about that next week. Sergeant Bruce Morse posted this on your door. It was published in the, I think, Career Commercial back in June of 2024 that the sheriff's sale would be in August. They posted it on your door. You didn't show up at the sheriff's sale. It was actually adjourned from July 11th to August 22nd. So they did post it on your door. And then you got notice with this when they served the notice to quit on you several months ago. But you do know you haven't made any payment on the house probably in 2 years. So they're foreclosing on that. So we'll talk about that. You may ask for 30 days or something, and they may be willing to grant that. Ms. Abu can check with her client and see what consideration they can give. But I would suggest you start making plans to move. The date would be May 12th. If the plaintiff agrees, they could give you more time than that. So we will do this again next Friday at 3 o'clock.
What happened to Abby in the picture? Goodbye now. Whatever.
Do you want to ask for more? What did you ask? Another question?
No, we just thought that since my daughter took over the contract and he's buying it, that it would clear his record and wouldn't have to mess with this at all because she's buying it.
I don't know about that. So your daughter's buying the property?
She physically told me she already has agreement and stuff and that she's buying it. I can get her out of there next time you want, but.
Well, they haven't got possession of it yet.
What's your daughter's name? You got to move, but she wants us out in a few months anyway, so we were trying to do that. That's what we started working on.
What's your daughter's name?
Abigail Butts. I think she's still got her original last married name. She hasn't got rid of that yet.
And she is purchasing it from who?
She says she's got the bank approved through some bank to buy it, and it was already approved that she was buying it. She's moving.
All right, well, let's talk about that.
Here, and I took care of her kids for 3 months and didn't get paid a dime. I'm trying to help.
They can't sell it until they take possession of it. They don't have the authority to sell it right now. So she may have a bank ready to loan her money to purchase it, but it isn't for sale yet.
So
All
we
right.
waited that long because we thought she was doing something through there. Oh my God.
Okay.
Okay, well, I
All
guess
right,
we're
we'll
lost.
talk
too.
about
So
this.
what we're gonna do is just try to move as soon as we can. I don't care
All
what's
right.
going on. This is all a bunch of crooked shit. We're just gonna get out of it. We're gonna move. And if you don't get his record
Sir?
straight,
Sir, I don't want you to
sorry.
curse on the record. And it isn't
Oh,
crooked. Your
did I
son didn't
curse?
make the payments.
Oh, I
They
said
gave him
shit.
notice.
Oh.
You've been living there free for 2 years and
Okay,
somehow the
okay,
banks are
but
crooked.
we were trying to move. We're trying
We'll
to
be
do this.
back
You
next
know what
week
time is
at
like.
3 o'clock. You can rant at each other there in the apartment and I'll see you next week.
All right, thank you,
There
Your
may
Honor.
be some crooked stuff going on, but I don't think it's the bank. All right, Ms. Albu, thank you. I did most of the talking and you just had to sit here and listen to me, but we'll see what we can do next week. And if you check with your client, they can give them some additional time to vacate.
Yes, Your Honor.
All right, thanks a lot.
Thank you.
There we have it, guys. I don't understand what was going on there. I don't know if there's something wrong with the son or if he's high or both. Very unusual situation. Obviously, the father has a problem with his motion regulation. But anyway, lads and lassies, let me know in the comment section what you thought. I hope you all have an absolutely lovely weekend, and we'll catch you next time. Sláinte. Hey guys, so I just came across this court. It's actually the first time I've ever covered it. The minute I clicked on it, there's a guy in there having a little mini meltdown, a bit of a poor me, woe is me kind of a scenario. Basically, he hasn't been able to pay his rent for whatever reason, and that's fine. They've tried to work with this guy, but he's just not helping himself at all. Like, even remotely, the judge tries to kind of explain to him. He's like, gets all smug and all entitled, and basically he says straight up on the record, yes, this is what I agreed to, but it's ridiculous that it's happening to me. Oh, poor me.
Yes, ma'am.
I'm here for the plaintiff.
Okay, that's Miss Jessica.
Yes, Your Honor.
Okay, and Mr. Bryant's here too. Let me swear y'all in. Do each of you swear to tell the whole truth and nothing but the truth?
Yes.
Your Honor.
Can you hear me?
Yes, you're coming in loud and clear.
Okay, very good.
Let me ask Miss Jessie just a couple of questions. The rent is $16.72 a month. Is that correct?
Yes, Your Honor. On the ledger, it states it's $15.09 for the rent.
Well, I took this off the petition.
Yes, I understand. It included other things, so I wasn't sure if we
okay.
could use that amount. So the rent portion was just $15.09.
It was $15.09? Okay.
Yes.
And y'all wanted back rent from March through today, is that right?
Yes, and for March, I got $1,400.40, and then I prorated April, if that's okay, for $1106.60, and I got $2507.
$2507. Okay, excellent. And 15 to the appeal bond would be 3,018. All right. And let's see. Is this property covered by the CARES Act?
Not that I'm aware of, Your Honor.
Okay. All right. Okay. Mr. Bryant, did you want to respond?
Yes, ma'am. So basically, the staff has been great here at Camden, and they've been working with me. I lost my job for about 4 months. I build custom homes in Westlake Hills. So, but because of the interest rates, I was laid off. I'm a project manager. I was laid off for like 4 months. Finally got it takes a long time to get a 6-figure job. So,
yeah.
But and I had to actually had to borrow $30,000 from a family member just to get through, because it takes $8,000 or $10,000 a month just to keep the doors open, of course.
Yeah, that's terrible.
So, yeah, it is, but the staff has been great. Um, I have the money. Of course, I have the money, and I've offered to pay partial here and there, and they keep denying me, and they just keep adding on fees. They keep adding on fees, which makes it more difficult for me. And like I said, yeah, the manager and everything is like, they like me here, and this is a great property. However, I think that adding all these extra fees is unfair due to my circumstances, but they, however, have they have no mercy, is what I'm saying. And I mean, I have the money to pay everything. However, I'll be penniless. Therefore, daily, gas, food, getting to work, blase, blase. That would be very difficult for me to pay the entire amount they probably added on almost $1,000 of the fees. And it's just ridiculous. And so I'm going to appeal if this for sure. And yeah, I'll go to trial, get a jury, whatever we need to do. But I think that like I said, they have been working with me, and then they decided, just not to work with me anymore. And it's not like I had to borrow $30,000 just to stay here for 4 months. And with the market,
Mr. Bryant, you've got the 6 days to appeal, and they can tell you exactly what you owe because all these fees are outlined in the lease that you signed.
I understand.
They're not making them up.
No, I know. And I think it's ridiculous.
And they change every day because the fees add up every day.
Oh yeah, I know. They're like blood sucking ticks.
Well, I'll get you a copy of the judgment at the conclusion of the hearing today. And if you want to appeal, you have that right, and you have at least 6 days to appeal.
Okay, here's the deal, Judge. I can't have an eviction. I have a clean record. Period. So this is I can't have an eviction on my record. Okay.
Well, you already have one because they filed it. Okay.
So I'm going to have an eviction.
It shows that one was filed, and if you take care of it, that's as far as it goes.
How long do I have to take care of it?
Well, it'll be a final judgment if you don't appeal within that 6 days.
I'm going to appeal for sure.
Okay, then we have the information available to you on how you can do that. Okay.
Yes, ma'am.
And Ms. JC, is that part of that going to be on the judgment, or is that just?
No, when I email the judgment, we'll include an eviction appeal packet with all of that information in it.
There you go. Okay. You'll get all that information, Mr. Bryant. And if you've got any questions, just contact the civil clerks at JP3, and they'll be happy to help you with the procedural questions.
Yes.
Okay.
Yes, Judge. Thank you.
But thank you very much for appearing today.
Absolutely.
And I hope you have a good day.
Absolutely.
Thank you, Ms.
so
Jessie, as well. Y'all take care.
I have other cases, Your Honor.
So yeah, you get the whole entitlement, the smugness, all that kind of stuff. But I'm just going to show you how cases like this probably should go. And I just got to say, this judge is like the sweetest person of all time.
Okay. The next one I have is Barto Terrell, DBA Skyline at Barton Creek versus Jorge Diaz.
Yes, Your Honor.
Oh, is that one for you too? Okay.
Yes, Your Honor.
Is Mr. Diaz here?
Yes, ma'am.
Okay. Thank you. Let me swear you in. Do each of y'all swear to tell the whole truth and nothing but the truth?
Yes, Your Honor.
Yes, ma'am.
Okay, thank you very much. Miss Jessica, the rent is $10.79 a month, is that correct?
Yes, Your Honor.
And y'all wanted back rent from February through today, which I got to be $29.49?
Yes, Your Honor. If I could amend that, he must have made some payments. So I got March $483.93. And then if I could prorate April, I got $791.26 for a total of $1,275.19, Your Honor.
We'll just say $12.79, okay?
That sounds great.
And then the appeal would be
$12.75.
Oh, $12.75?
Yes, Your Honor.
Okay, excellent. The appeal bond will be $2,158. Okay, and this is covered by the CARES Act?
Yes, it did show as a covered dwelling, Your Honor.
Yes, okay, excellent. Mr. Diaz, would you like to respond?
Yes, ma'am. So, in end of January, pretty much all of February and most of March, I was on medical leave from work, and I thought that I would get paid. And like my company was telling me that, yeah, you just gotta, there was something called Sedgwick, some company I had to like send paperwork to. There was a delay with my doctor and all kinds of other stuff. Long story short, I ended up not getting paid for basically 2 months. Now I'm good. I lost my voice for just 2 months. And I'm good now. I'm back at work, and actually, if it is just the $12.79, I should have that tomorrow. Basically, I get paid tomorrow, and I'll have that. I can cover all of that.
Okay.
Now, I might still be a little bit late on May rent, but I should be able to cover it as well, and I'll be fully caught up by like the first week of May.
Okay. I really hope that, I think that's wonderful. And I hope you're better. I hope everything is resolved. It's really hard, especially when you aren't working, to not get paid.
To be fair, I didn't really set myself up for success in this one either. So, but they've been lovely. Like the Skyline staff here, they've crossed every T, dotted every I. They've been very communicative. So.
Well, like I say, what you may owe under the contract is going to be more than what the judgment's going to be for, because you have to pay a whole month's rent at a time, and this is just prorated through today. But go visit with them and find out what you owe and how you can pay it, and tell them what you've got, and hopefully you'll be able to work something out. Okay?
Well, yeah, because I'm at the 12.79 feels a little bit lower than I thought it would be. So I'm just a little unclear on that.
It is lower because you don't pay. The statute says the court can only award back rent, so we prorate for April. But under the contract, of course, you owe all of a month's rent at one time. They don't prorate. That's why it's different. So we'll get you a copy of the judgment, and then Miss Jessica, does he know who to talk to at Skyline at Barton Creek?
Hi, Judge. I'm the community manager, Daniel, at Skyline. We're open today until 6. So if you'd like to buy, you can visit with our staff and we can see what we can do. Because it is a different amount that we have, but we'd love to see what we can do to fix it and keep him here. So absolutely.
Okay. So Mr. Diaz, you can visit with Daniel at the Skyline place.
I can go right after this if he's available.
Yeah, that'd be great.
Yeah, that's fine. Absolutely.
Yeah.
Okay. Well, thank you both to Mr. Diaz and to Daniel for appearing. And I appreciate y'all being in the court today. I hope you have a good day.
Thank you, Your Honor.
Get those judgments out. Y'all take care.
Yes,
Thank you.
So there we have it, guys. There's no talking to people like this sometimes. It just thinks that the whole world owes them a favor. The guy literally said that he has the money to pay for it. Then feckin' pay for it. Pay your bloody rent. Anyway, lads and lassies, I hope you enjoyed that. If you did, make sure and hit that like button. We'll catch you in the next one. Slán.